within a group, forcibly transferring children of the group from one to another. Because genocide is the intentional destruction of a national, ethnical, racial, or religious group in whole or in part. No other categories at the moment within that definition. It has to be a national group, or an ethnic group, a racial group, or a religious group. And if there is an intention to destroy such a group, then that is genocide. That's remained the definition since 1946. I can tell you that at the IBA annual conference in Vienna in October of this year, the War Crimes Committee, of which I'm chair, is putting on a session at that conference to look at genocide again and look whether the definition of genocide suits the modern era. It suited 1946, but whether, for instance, a political class should be included. You get states like North Korea, where the ruler has killed all political opposition and forced conditions of life upon them that are deliberately aimed at causing the destruction of any political opposition. So there is an argument that maybe genocide should be extended, but there's an issue that in the hands of a misguided prosecutor, it would be used in every case, whether there was validity or not, because a lot of these international cases involve politics. And from my own perspective, I would have imagined that the prosecutor at the International Criminal Court in the Kenyatta case, if he could see such an opportunity for publicity, would have made such a charge, even though it wasn't actually applicable to those facts. And that's one of the problems in extending the category into the political arena. But we will debate that in Vienna. So genocide has, I think, 4 different ways of being committed. The substantive offence of genocide. You can conspire to commit genocide. You don't actually have to have caused the genocide itself. That doesn't have to have been the result. If you've conspired to commit genocide, that's enough. Incitement of the public to commit genocide, and attempt to commit genocide. So inchoate and coate forms of the offence. And complicity in genocide. So the lack of functional immunity in relation to this particular crime is obvious. Why universal jurisdiction says, incumbent heads of states, if they're in an international criminal court, cannot be subject to an exemption of functional immunity in prosecution. Let us now turn to the next crime to be considered as an international crime. It's the one most used in most cases. It's called crimes against humanity. And it is a widespread or systematic attack directed against a civilian population, and knowing that that attack is taking place. And it also has to be at the International Criminal Court as part of a state or organisational policy. State, we understand. Organisational is more difficult to concept. In the Nuremberg trial, there was a whole section of the indictment reserved to organisations that had supported the Third Reich and had been responsible for serious crimes. So this concept of organisation is one of a group, a body that has state-like qualities, that has its own ruling system of its people, is able to sanction people, control them, tell them what to do, then such a body like that is capable of being an organisational body capable of making a policy that would cause crimes against humanity. So a very important capacity issue. That's at the International Criminal Court. Actually, in national legislations, you don't need that aspect of state or organisational capacity, because it's at the international level where you get the really big crimes. When someone says an international crime has been committed, it's because it's so serious that it can exceed even the national capacity of prosecution. It merits prosecution in the international community. So at a state level, you don't need that. You just need to have a widespread or systematic attack against a civilian, directed against a civilian population. And in many jurisdictions, that would be sufficient. It's not a one-off matter. I remember Swedish TV interviewing me about the man who killed all those students on the island in Norway. Was it Sweden, Norway or Sweden? And he was attacking a large number of people, and they said, oh, we're going to charge him with crimes against humanity, what do you think? I said, well, he's not directed it at a wider civilian population. He's committed 100 murders, yes, but what you have here is you are exaggerating the context of a single incident on an afternoon in August to being some kind of bigger event and saying it's a crime against humanity. And in my view, such a prosecution should not succeed. And in fact, the original intentions of the state changed later on, and they just charged him with specific counts of murder. Particular crimes that you have to have committed to come within the context and framework or chapeau, hat, of crimes against humanity are the crimes like murder, extermination, enslavement, deportation, forcible deportation, torture, sexual crimes, rape, sterilisation of women, all directed in a way that they are inhumane acts against people during an incident or a conflict. Sorry. Of interest is this: you can specifically commit genocide in peacetime, and actually Article 1 of the Genocide Convention says that you don't need a war. And crimes against humanity, you don't need a war. It can be committed in war, conflict, and peacetime. So even though there's peace, you could still be responsible for committing this particular offence. The important aspect is this attack directed against the civilian population. That's got to be the context. It's not the intent to destroy a particular part of the population as such, but it's an attack against the civilian population. So there we've covered the three major international crimes. As I said, torture is one that has been made the subject of an international convention. There is also a trial going on in The Hague at the moment at the Special Tribunal for Lebanon through a UN ad hoc court, a Special Tribunal for Lebanon, for the offence of terrorism. The offence of terrorism is not an international crime. This particular court has a troubled history and has very much a political motivation about it. It was set up because the ex-premier of Lebanon, Rafik Hariri, was the subject of a terrorist explosion, and the UN went into immediate action as a result of this because of the fragile nature of peace in the Middle East, and to cut a long story short, ended up setting up a UN ad hoc tribunal to try the people responsible for that assassination. Actually, the court doesn't have any defendants in it, and no one knows whether the people who are on trial have ever been seen in the last 5 years. There is no recorded sightings of them since the 2006. So the whole thing is a bit of a waste of time. And I mention that in case some of you are thinking that terrorism comes into that category of the three major crimes: war crimes, genocide, crimes against humanity, as being an international crime. Let's turn now to a very important legal issue in international crimes. It exists in different forms in national legislation, and that's the liability through command responsibility. You classically get this in the armed forces type conflicts or organised groups type conflicts where they have militia, private army groups formed as terrorist groups. But they are capable of having a command structure that is called command responsibility. So such people can be held responsible for crimes committed by others. So it's not a perpetration issue, it's not even a conspiracy issue, it's not even an incitement issue. Command responsibility comes about when a commander should have known or ought to have known that people under his command were going to commit particular offences, or if they have committed those offences without him being in a position to know about it, failing to punish them or take action or necessary measures against them. So command responsibility is a leadership form of criminal liability, and it doesn't have to be the people directly below you. They can be right at the bottom on the ground, and you can be the most senior military commander or the most senior paramilitary commander, but there can be a line of authority and communication that makes you liable for what has taken place on the ground, although there may be 5 different commanders up to the top level. And that's because it's well known that all military organisations as well as paramilitary organisations adopt structures of order from top to bottom down, and they give directions, and they have reporting systems. So although a commander may not have known that troops were going to do something, the fact of the matter is that if he finds out about it, he has a duty to punish them. So this is now a well-established form of criminal liability, and there have been many prosecutions of the Yugoslavia Crime Tribunal and the Rwanda Tribunal based upon this form of liability. We've dealt with terrorist groups, but I want to emphasise that they can commit international crimes, of course, as well. They can fit the definition of perpetrators and have the structure and intent in the same way as a state. And so such groups are liable for crimes against humanity, genocide, war crimes. And at the Yugoslavia Tribunal, the ICTY, there have been a large number of prosecutions of paramilitary leaders. Dusko Tadic, who I represented in 1996, was a classic local paramilitary leader. He wasn't a member of an armed military force. He was a local commander of an unofficial group that was connected to a force from what was then declared as Republika Srpska. So this can be committed by ordinary people in militia groups, these crimes, as much as by soldiers and politicians. Next very important issue we're going to move on to now, having looked at crimes, is the issue of complementarity. And complementarity is a principle of international law that looks at whether states have punished offenders of serious crimes nationally, and gives the opportunity and duty, in fact, and responsibility for states to undertake such prosecutions. So I'm going to read out what's in the preamble to the International Criminal Court statute as part of the Treaty of Rome, that I think probably best expresses it. And it says this: affirming that the most serious crimes of concern to the international community as a whole must not go unpunished, and that their effective prosecution must be ensured by taking measures at the national level and by enhancing international cooperation, recalling that it is the duty of every state to exercise its criminal jurisdiction over those responsible for international crimes. So, international law doesn't step in first. International law only steps in when the national systems of a state have failed to take action over international crimes. And Article 1 of the ICC statute, which establishes the court, says that it should be a permanent institution, have the power to exercise its jurisdiction over persons for the most serious crimes of international concern, and shall be complementary to national criminal jurisdictions. So international law, principles of sovereignty, require a state to have the opportunity to punish those responsible for serious crimes. And when that fails, it is only at that stage that the issues move on to an international court taking jurisdiction. And that's the whole principle of why the International Criminal Court was established under a treaty, and why the UN ad hoc tribunals for Yugoslavia, Rwanda, and let us say Sierra Leone, that was a national legislation, where the UN steps in, the international community steps in, is where a state is unwilling or unable to genuinely carry out investigations or prosecutions. So, an important issue that has to be raised here are the criteria of the international community, if you like, how they view the exercise of a state's complementarity. The ICC won't accept jurisdiction over a case if a case is being prosecuted transparently, is genuine, and is a proper proceeding. A false proceeding that's designed to mislead and is designed to pretend to be a proper criminal prosecution would be something the court would say, international community would view as being there a failure to exercise national jurisdiction, and as a consequence the court would step in and take over prosecution. So sometimes states don't have the capacity because they are unable to perform. They don't have criminal justice mechanisms that can work. This would have been the case in Germany after the Second World War. Other times, it is because a state is believed to have failed to exercise a proper jurisdiction, and it specifically says in the statute of the International Criminal Court that if the proceedings are for the purpose of shielding a person concerned from criminal responsibility, then the court will accept jurisdiction. Or indeed, if there has been unjustified delay in relation to bringing proceedings, if there has been much talk but no action. And we experienced this in the Kenyatta case at the ICC. Kenya was a state party. Kenya intervened once 6 defendants had been transferred to the court for jurisdiction, and Kenya intervened to say, hang on here, we've altered our constitution, we've altered our statutes, we've reformed our judiciary, and we must have these individuals in our own jurisdiction so that we can exercise complementarity, because whereas we failed before, we're now able and have the capacity to prosecute, give them to us. The court held this has been too long, there's been too much delay, we're not satisfied that indeed you have a genuine setup, you haven't arrested any of these people, a number of them haven't even been interviewed by police officers, so we don't accept that you should be entitled to exercise complementarity. We are doing it better or worse. So, there you have the issues, the kind of state, you have the crimes that can be committed, the kind of responsibility, all those matters that we've covered this morning, and you have, let's say, a failure to proceed with criminal proceedings. So let's look now at the legal issues of trigger mechanisms for international courts. When is this taken out of the hands of a national jurisdiction? First of all, let's look at the UN ad hoc tribunals, Yugoslavia, Rwanda. Now, those tribunals were set up under the authority of the United Nations through its powers of the Security Council under Chapter 7 of the UN Charter. Chapter 7 of the UN Charter entitles the Security Council to take measures to restore peace and international security. In a famous decision called the Tadic jurisdiction decision, the before Dusko Tadic went on trial, the court said